Thank you very much once again, Manyeti, and I hope our viewers and listeners are all still hooked up with us and are glued to their sets and listening to us. Now we move on to EU law and what the position is at the moment since the deadline date of June 2021. I suppose you'd appreciate that the June 2021 is not just the one deadline date that we've had, but then you can appreciate back in December 2020, we mentioned that 31st of December was going to be the deadline for EU nationals and their family members who are seeking to come in. So that very particular date was for EU nationals who were seeking or looking to come and then reside here in the UK. And then since that, if you were here in the UK, then you were required to make an application to the Home Office and that the EU settlement scheme, or if you like, Appendix EU. And so that June deadline was for those who were here as at the time, or those who had been granted some sort of residency here under the EU rules back then in the UK. Now, there's been a whole lot of discussions going on around town, and what people want to know is whether or not, because the June deadline is now passed, the EU law is stopped to apply to EU nationals and their family members. We say no, and I've said this before, and I'm going to say it again, that the EU law and its application and EU migration is going to go on for a very long time to come, because there's still a lot more which is got to be done. So for instance, there are people who have made application and are waiting on decisions. There are people who have been refused and are going through the appeal processes. And so all of these people you'd appreciate would have some sort of a claim to the EU right when it comes to that time. And so it would take a very long time for us to, if you like, jettison the EU migration rules. And to that effect, what we're saying is that the rules still apply. And so if you're an EU national and you have a spouse, or you have a child, or you have a parent who is back home in a third country outside the UK, then you're still permitted, you're still allowed to make an application for this family member to join you here in the UK. And it doesn't matter the deadline date, which was June 2021, or the deadline date, which was December 31st, 2020. Now, with the December deadline, all that is required is that you, the EU national, should have been here in the UK and would have made an application under the EU settlement scheme and been granted either leave to remain, which is a pre-settled, or indefinite leave to remain, which is a settled status. That would put you under the category of those that we call relevant EU nationals. So bear in mind with that one. Now, again, if you're here and you have been given leave to remain under the scheme, you can also go and then bring your partner or your children, because since the advent of the Appendix EU and the EU settlement scheme rules, what the Home Office has done is that they have moved people who are on the 5 years limited leave to remain into the EU immigration, into the domestic immigration rules. And so where we have people joining their spouses who are British nationals or are settled here in the UK and are here with indefinite leave to remain, humanitarian protection leave, and all of those leaves. Now, if you're EU national and say, for instance, you missed the opportunity to form a relationship with your partner who is outside the UK, you haven't lost out. And the reason being that because you have been granted leave to remain, you can still make an application under the immigration rules to basically get your family members to come and join you here in the UK. And this is very unique in the sense that from what we know from under the immigration rules, you could only bring your spouse if you had indefinite leave to remain, or if you were a British citizen, or you were settled here in the UK of some sort. But now we see that even if you have 5 years limited leave to remain, for especially EU nationals and their ex-family members, if you have limited leave to remain, the rules now allows you to be able to go and then marry your partner who is in Ghana, who is in Nigeria, who is anywhere else in the world, but is living or is a third country national. So if you're that sort of person, then you can make an application to go and then bring your wife, which is very, very good for all of us, because then if you thought that you couldn't do it, now you know that you can do it. The only thing that you need to do is that you have to meet the same requirements as those of us who are British nationals and were seeking to go and bring our family members from outside the UK. And so what are the requirements then? The requirements are that you should be somebody who is earning at least, if it's just your partner that you're seeking to bring into the UK, you should be somebody who is earning at least 18,600. And this is where the dynamics are, because obviously you appreciate that under the EU rules, you were not required to meet any financial requirement. This is not the case with this one. And I'm sure you'd be very grateful knowing that even if you have a 5-year limited leave to remain, the rules allows you to bring your family members into the UK. So that's a bonus for you. So the other thing you need to be sure that you meet is that you need to meet the accommodation requirement. Your partner that you're bringing in needs to meet the English language requirement at least level A1. If they're good enough, they could do a B1, and then they would need to do a TB test as well if they're coming in. The other thing is that you would have to have met this person. Okay, so that's one of the rules in this under this immigration rule. You should have met this person. So whereas back then with the EU law, yes, you're on the WhatsApp chatting, you're on social media platforms chatting, and so that was fine. And that this immigration rules, you should have met this person. And meeting this person is not communicating over the phone or on social media. Meeting this person is actually meeting them face to face. So please take note of that. Now, once you've done all of these things and you've basically ticked all of these boxes, then yes, you can say yes, your partner can come and join you, including any children of your partner who are seeking to come with you. Just that if you're looking to get your partner's kids here, i.e. your stepchildren here as well, then your salary per annum would increase depending on how many children you're looking to bring into the country. So take note of that. Now, that's for the EU nationals who've been given limited leave to remain or indefinite leave to remain. But the door is still not shut, and so you can still do that. Even under the EU immigration rules, there's still room for you to be able to make the application. But the caveat is you should have formed your relationship with your partner before the deadline date of the 31st of December 2020. If that fails, you have an exit through the immigration rules to go and then see your partner in Ghana. If you've met them already back then and you knew them even before you relocated, that will still be enough to say that you know this person. Okay. Now, if you're a family member, ex-family member, say for instance, you're somebody who was granted limited leave to remain as a family member of EU national, and now you have divorced, you've gone through the process, and now you're your own person because your marriage didn't work, and now you're by yourself. But then you've been granted limited leave to remain, or you've been granted settled status or indefinite leave to remain. What I have just discussed would apply to you as well. So if you're somebody who's retained their rights and now you're living by yourself, you found somebody outside the UK, you formed a relationship, you know them, you've seen them, and you want them to come and join you, the same rules as I've discussed with the EU nationals would apply to you. So you need to tick all of the boxes. You meet the financial requirement, accommodation, and your wife should meet the English language test. You should have met all of those requirements would apply to your case as well. So please take note of that. It's a very good thing that has happened, and we need to take advantage of it. It never used to be the case that if you're here with limited leave to remain, that you'll be able to go and then get your partner to come and join you. And it's still the case, indeed, that those of us here with 2.5 years limited leave to remain are still not allowed to bring our partners here into the UK. And so that's why it's very, very good news that we take this thing very seriously. So please take note of that. Again, if you have a child in the UK who has a limited leave to remain under the EU rules, under Appendix EU or under the EU settlement scheme, again, you can make an application for leave to remain here in the UK. You may probably have a direct access to that child. You will still be allowed to live in this country. However, a bit of a caveat there with somebody who's got direct access to a child who has limited leave to remain, or if you like, pre-settled status under the EU settlement scheme. This would be based on purely Article 8 maneuvers and then sprinkling a bit of spices on it to make it very solid so that you can go through smoothly. So please take note of these dynamics in the game, and that's why we come here all the time to discuss these things with you, because they're very, very dear to our heart. And like my senior partner and principal would always say, we don't come here discussing any subject at all. We normally come to discuss them with you because there are issues that have come in front of us and people have asked questions, people are in doubt. And so we come so that we can all share and then we can all take advantage of what the system is offering. So please take notes of these things and make sure you can make the application to live in the UK. If you have a child who is living here with a limited leave to remain under the EU settlement scheme and you're all living together, you can make the application. Even if it's your stepchild, you can still make the application and use Gen 3.1 and Gen 3.2 to make your application, citing all the reasonableness. And bear in mind, we have the exceptions as well, EX1A and ES1B, which you could apply to your case as well. So take note of these things. Now, those of you who made applications, especially under the immigration rules, under the EU immigration rules, who are still expecting decisions, yes, they're still coming in. If you've been refused, please, please, please don't relent and take a step. You would have to take a step. You would have to make an application to appeal against the decision. We have seen numerous of horrendous decisions come through from the Home Office. Some of them are very, very flimsy, especially someone tells you your signature doesn't match the one in your passport. So
yes,
your passport's got
Patrick.
different signature and your marriage certificate's got different signature. Now, that is absolutely non-starter for us. So we're saying if you're somebody who has been refused on that basis or any other basis at all, please go and speak to a lawyer. Go and speak to somebody who understands what they're doing.